Hello, Oregon brokers, and welcome to the 2022 OREF Form Changes course. I am Colleen Gordon. I am the co-chair of the OREF Forms Committee, and I will be presenting the changes to you today. If I could get a quick thumbs up from one person that you can hear me, we'll be ready to roll. I just want to make sure I'm being heard. There it is. Thank you. All right, so this is a webinar format class. So all attendees are muted automatically and your cameras are off. So if you're wearing jammies and comfies, you are good to go today. We are recording this session. We'll make the recording available on the orefonline.com website for on-demand viewing as well. So if you needed to hop off early for any reason, just know that that resource will be available. Joining me today is Christina. She is the Interim Executive Officer for OREF. Christina, you want to say hi?
Good afternoon, everyone.
Glad to have you here with me today, Christina. So just so everyone knows, we are going to be using the Q&A section on your toolbar for Zoom. You should see a Q&A. That's a great place to add your questions in. Christina's going to monitor those questions as we go through the material. So please note, we're at 465 people on the call. We have over 700 registered today. We want to get to all of your questions regarding the form revisions. So please make sure that your questions are staying focused on the actual changes of the forms. We have plenty of time at the end of the class to field additional questions, but Christina's going to monitor those questions and ask them as they come up with the material. A couple of things, just housekeeping things. CE certificates will be issued for this course. The staff at OREF will be putting those together once the class is wrapped up. Just give a few days grace period as we have quite a few certificates to get drafted. So those will be emailed to you with the same email address that you registered for the class. And just a reminder that all of the materials that we're covering today are subject to change. This is version 1 of the presentation. None of the slides have needed to change. I think we've got all the kinks worked out. If you go to orefonline.com, under forms, there is a 2022 form revision tab. There you can download the full summary of all of the revisions that we're going to be covering today, including the highlighted sections that you'll see on your screen. So that is available on orefonline.com. If there are any changes or updates, that's where we will post that information. So always check back to that site if you're looking for the most current information regarding forms. A little information about OREF. The Oregon Real Estate Forms LLC has been servicing Oregon since 1997. OREF is co-owned and managed by the Portland Metropolitan Association of Realtors and the Eugene Association of Realtors. The company is professionally managed by a staff of 4 in concert with a board of managers and a forms committee. Now, these two groups, the Board of Managers and the Forms Committee, are groups of volunteers. They are realtors appointed by each of the association owners. OREF prepares and licenses high-quality real estate transactions and advisory forms created by legal and industry professionals. Next slide, there we go. So if you have any questions about using a form, who should you ask? At OREF, we always recommend you start with your managing principal broker. If you have a question about a transaction, a form, what form to use, starting with your principal broker is an excellent local resource for you. If there are if there are questions specific about any of our forms, feel free to email customerservice@orefonline.com. The customer service department will work hard to answer your question as best as possible. The email is the preferred method so that the customer service department can tap into the network of professional committee members to get you the best answer that you'll need. If you have suggestions for a form or a form revision, email customerservice@orefonline.com. We love suggestions. Many of the changes that you're going to see as we go through the revisions today came directly from subscriber recommendations or changes, updates, or new forms or resources. So please know that the committee does listen to all of those requests, evaluate how best to implement. So please email your suggestions in. Again, that's customerservice@orefonline.com. So we're going to start by jumping into the two new forms that we've added to your OREF library. These actually hit your platform providers last week and are currently available for use. The first form is called Offer Summary. This is OREF 101. Now, this form was created to assist buyer's agents in summarizing the key terms of an offer. This is in conjunction with Form 001, the residential sale agreement, and a buyer's agent can use this as a cover page to an offer when submitting the offer to a seller or seller's agent. It takes all of the populated fields within the sale agreement and pulls them together into a one-page summary of all of the terms. Now, listing agents who receive this form from buyer's agents may choose to provide this as a summary to the seller who has received multiple offers on their property as a way to compare the terms of the different offers. Just know this is not a substitute for an actual offer. This is simply a summary or a cover page to the offer. This should never be used in an effort to negotiate terms. This is feeding directly from that offer. So in your forms platform, as you're completing your residential sale agreement, all of the fields should be populating into this offer summary as well for you. So these terms are only going to reflect the buyer's initial offer. It does not need to be filled out separately. It would be done in conjunction with that residential sale agreement. There are no signature or initial lines. This is not a tool to negotiate terms of the offer. So it's not signed by the buyer or the seller. It does not need to be necessarily reviewed by the principal broker because it is your actual offer that is the contract being presented. So very important to note that this is a tool. This is not intended to be an instrument to bind your clients. Do we have any questions yet, Christina, on the summary?
The only question that came in was asking if this is required or if it was optional. And I did respond in the Q&A that it was an optional form.
Perfect. Yes, completely optional. This is a resource that we had a couple of different subscribers request that they have gone through the process of creating their own offer summary over the years. But how nice would it be to have something that populates straight from the OREF form? So totally an optional form, in no way required to be used. It's intended to be a convenience for those subscribers who choose to use it.
We do have a few more questions that came in.
Okay.
Does this summary populate into the Sky Slope forms? And I believe that they do, but we did recognize that not all of the fields are being populated, and we're working with that platform provider to get that corrected. And they also asked, can you upload into the summary and have it populate into the contract? And we had directed our platform providers to have it be one way from the offer into the offer summary form, not to go back and forth. That's one of those things that we'll have to work on with them to get this function working the correct way.
And I think the one way was honestly by design. We don't want there to ever be any confusion that the offer summary could be used as an offer. So as you're filling out an offer, it will populate onto the summary form for you.
Yes. And I think we covered the questions so far.
Right, excellent. The next form we've added to your forms library is advisory to buyer, recording devices may be present. So this is a new form added as a risk reduction tool for buyer's agents. The thought here is that you would present this to a buyer prior to actually taking them out and viewing property. It cautions the buyer that while touring property, there may be undisclosed recording devices in the property. It's suggested that buyers wait until after they have left the property before engaging in conversation about their interest in the property. Good or bad, positive, negative, whatever comments, always best to hold those until after you've left the property. Buyers are encouraged to speak with an attorney if they have questions regarding the legal aspects of recording devices. As realtors, we cannot be giving legal advice or interpretation of the statute. So if your buyer has questions regarding the legality of those recording devices, always recommend they consult with an attorney. Any questions on that one, Christina?
I'm taking a look and not on this form.
Okay, excellent. So we will move into the forms
I'm
that.
sorry, we did get
That's
one.
okay.
Can this one form be used on multiple showings?
Yes, so this is a one-time form, similar to your disclosed limited agency or your initial agency pamphlet. Once you've delivered it to the buyer, it has served its purpose of warning the buyer. It doesn't need to be signed every time you're going into a property. The idea is that in your buyer consultation, as you are establishing your working relationship with your buyer, it's a good way to educate them on some of the things they may come across as they're touring property. So no need to have it repeatedly signed unless you have concerns of retention or understanding with your client and you want to revisit it just to protect their interests.
A question came in asking if it is required or if it's optional.
That is a question to ask your principal broker. So OREF does not dictate any forms that are considered required forms. That would be specific to your individual brokerages. So I would encourage you to check with your principal broker on whether or not they will be requiring any particular forms.
And another question came in, is there any form for sellers to disclose if they are recording?
There is not. An excellent suggestion. If you would like to send that into customer service at orefonline.com, the forms committee is glad to look at that. I can speak specifically to RMLS. As we were working on, the forms committee was working on this form, we did reach out to the forms committee for RMLS, asking if there would be any additions to the listings as they're published on whether or not the sellers have recording devices on there. Have not heard back whether or not that's actually going to roll out, but for seller disclosure, that may be another option, is talk to your local MLS and see if that is a field that they would consider adding to their data input regarding the status of the listings for showings.
Thank you.
You're welcome. All right, so we're going to jump into our revisions. These are the forms that were already in your library that have had some changes. We'll start with some general library changes. The header and the footer for all of the forms has been updated. OREF has a new logo, which you will see consistently in the upper left-hand corner of your forms, along with the equal housing logo. On the right-hand side, you'll see the name of the form. And then in the footer, it was updated for consistency throughout, including at the far right side, you'll see that there is a version number. So if changes are made through the year, you'll be able to see not only what year is this form published with the copyright year, but what version of this form are you looking at as well. Other general changes, the phrase counteroffer as 2 words was changed to counteroffer 1 word throughout all the forms. The abbreviation for IE was changed to that is. The abbreviation for EG was changed to for example. References for AM and PM were changed for consistency to lower cap with periods. Advisory forms received a title update. So I believe we have 12 advisory forms in our library now. For subscribers' ease of locating those forms in your forms library, they all now start with the title advisory, followed by who the advisory is for. So advisory to buyer or advisory to seller. If it is a neutral form that could be used for buyer or seller, you won't see that distinction. It will just be advisory and then what the title of the form is. So advisory, warning regarding electronic funds would be a form that could be used for buyers or for sellers. So no distinction on that form. Now, the first form that you'll see a change on is the Oregon Real Estate Agency initial agency disclosure pamphlet. This is form 42 in your forms library. This form had a change as the result of the passage of House Bill 2550. So this is the only change you'll see in our form revisions that is directly related to a statute change. So this is the one that becomes a mandatory change. This bill went into effect on January 1st, 2022, adding a new statement to the duties and responsibilities of a seller's agent. So you'll see that new information added. It's highlighted in yellow as the last statement under the seller's agent's duties. In order to help a seller avoid selecting a buyer based on a buyer's race, color, religion, sex, sexual orientation, national origin, marital status, or familial status as prohibited by the Fair Housing Act, a seller's agent shall reject any communication other than customary documents in a real estate transaction, including photographs provided by a buyer. So that change is already in effect. You'll want to make sure that you are using the most current version of the initial agency disclosure pamphlet as you deliver that form to prospective clients. Any questions on that one?
Let's see. We got a question from Wendy. If we have one in place, have one re-signed?
Not necessarily. If you covered the initial agency disclosure pamphlet prior to the change of form, it should not be necessary to go reintroduce that, assuming that you covered the initial agency pamphlet with your client prior to the new statute taking effect.
Another question came in asking if a picture of a dog can be sent.
Well, there's no restriction on what a buyer or a buyer's agent can send. The restriction falls on the seller's broker in what they forward on to the seller. So this is intended to eliminate the love letters that may have a seller making a decision based on the people who are buying the property rather than the merits of the offer. So it's going to be a question of whether or not a listing broker can forward that on to their seller, not whether or not a buyer or buyer's agent can submit it.
We had another question come in. As a buyer's agent, can you tell the listing agent something about your clients when submitting their offer?
As long as you're not violating fair housing, I would think yes. So I can't speak too much to that or to the intent behind the statute other than to protect the seller from a potential fair housing claim. So as long as the information is related to the merits of the offer, the ability of the buyer to perform, I think that's great information for buyer's agents to relay to listing agents.
And then we had a question about how do we know what version is in effect?
If in terms of the initial agency disclosure pamphlet, if you see this last statement in the seller's agent's duties, you know you're dealing with the most current form. If you're in your OREF forms library, you should only see, unless you have it saved as a template, and you need to change out your template, you should only see the 2022 versions of these forms now.
Thank you.
You're welcome. All All right, the next form to receive a change is the seller's counter offer. This is form 003. This change you will also see in the buyer counter offer and in the sale agreement. So the following sentence was added just prior to the seller's signature as a reminder to the seller to fully review the seller representations in the sale agreement and correct in writing if anything is incorrect. So section 14 of the sale agreement is the section that is called seller representations. And in there, the seller makes contractual representations to the buyer regarding the property and the seller's knowledge of the property. This reminder was added at the point of a seller signing a counteroffer to remind them to review those for accuracy. And if anything is incorrect, that seller counteroffer is a great opportunity for the seller to make those corrections before submitting it to the buyer. So then we go on to form 004.
Oh, 1 second, we have another question come in.
Okay.
If you have an offer that has held over from a previous version, is there a responsibility to real estate disclose such as advisories? Oh, to redisclose, sorry.
To redisclose regarding representations? I'm not sure I understand the question.
Let me see if I can. If you have an offer that has held over from a previous version, is there a responsibility to redisclose such as advisories? So maybe this is a discussion about using the 2021 version of the OREF forms versus the 2022.
Okay, so yeah, that I can definitely answer. So because there were no statutory changes to the sale agreement, the counteroffer, any of our advisories, there was no law change. The 2021 versions can still continue on. So if you wrote an offer prior to the form revisions, nothing needs to be rewritten, redrafted, revisited by a seller or a buyer for accuracy. It is not statutory changes that we're reviewing with anything other than Form 42, that initial agency disclosure pamphlet. So if you are already in contract, or if you receive an offer today that's written on a 2021 sale agreement, if the buyer and seller are in agreement on terms, no action is needed. We do want to make sure as realtors, we're always using the most current version of forms, but every year when we have this form revision change, there's always that little grace period where we've got people adjusting and updating their templates in their platform provider to make sure they're using the most current version.
Thank you. And we have one more question regarding 003. Why do we include this section in the PSA at all instead of just stating the seller will disclose any issues? There's no way for a buyer's agent to know the answers.
So in any contract between buyer and seller, the buyer is making representations and promises to the seller, and the seller needs to make representations to the buyer. So this is definitely something that has come before the committee. We have consulted with legal counsel on this matter. The seller representations is a standard portion of any real estate contract where buyer and seller are making commitments and obligating each other within the contract. So the seller representations that we have in the sale agreement are pretty boilerplate. The seller would need to correct anything that's incorrect when they receive an offer. So unless the listing broker has added into the MLS any of those corrections, the buyer, when they're drafting the offer, is relying on those boilerplate representations. It becomes the responsibility of the seller then to correct if any of those representations are inaccurate.
Sorry, my mouse moved on me. Another question came in. It said, is the statement regarding seller representations included in the sale agreement as well, or just in the counter offer?
It is in the sale agreement as well. We'll get to that as we go through. So our next slide is the buyer counter offer, which that statement is added just before the seller signature, before the seller responds. So if they are going to bind themselves by accepting this offer, again, that reminder to review those seller representations. If the seller knows that the visual property lines are not the same as the actual property lines. The seller has that knowledge. They need to correct the seller representation before they get into contract with the buyer to make sure they haven't misrepresented about the property. So this is that, again, reminder to the seller, check those representations, make sure all of that information is correct. And it is added when we get to the residential sale agreement, it is added to the section where the seller accepts the offer. Again, the same exact language added, reminding them to review that.
So a question came in saying, so that cannot be added with an addendum?
The requirement is simply that it's promptly corrected in writing. So if it is in writing from the seller property disclosures or an addendum to the seller property disclosures, a counteroffer, as long as it is promptly, so fast, quickly, not right before the end of the transaction, presented to the buyer in writing. So it could be seller accepts the offer, and by the way, buyer, here's an addendum explaining what I know about the visual versus actual property lines.
Another question, if the seller's property disclosure statement contradicts the seller representations in the sale agreement, does that qualify as a notice to the buyer?
It does. I believe section 14 has language specifying that the seller property disclosure statement would supersede.
Thank you. Oh, one more question. Does this apply to commercial sales too?
No, this is in the residential sale agreement. Although I do believe, and Christina, I might need your help on this one. Did this change also go into the OREF commercial sale agreement?
I will take a look. I have to see.
Okay, I believe it did, but I'm going off of memory, so bear with us. All right, the next form that has a change is the final agency acknowledgement addendum. This is form 010 in your forms library. This form, because it is an addendum to a sale agreement, we just made some changes to the overall look. It is now reflective of the rest of the addenda in your OREF forms library. So at the top of the page, we've added buyer, seller, and property address. This form is intended to be used when a non-OREF sale agreement is being used by the parties. So it could be a situation where the builder developer has their own forms that they want to use, a bank-owned property, and the asset management company has their own forms they want used. If those forms don't have final agency acknowledgement built into them, we've added this as a separate document in your forms library for you to incorporate into that offer. Remember that license law requires that any transaction that involves licensees, the offer itself has to include a final agency acknowledgement. Who is representing who in the transaction? So this form actually does not need to be used if you are using any of the OREF sale agreements. That final agency acknowledgement is already built into the OREF agreements on the very first page. All right, so now we're going to get into the residential sale agreement. Now, in the interest of time, we are only going to cover the residential sale agreement, but most of the changes that you're seeing on the residential sale agreement translated into all of the other versions of the sale agreement. So the new construction, the farms and ranches, the vacant land sale agreement, all of these changes that you're going to see here, if applicable, are also going to appear in those forms. One other sale agreement did receive some form specific changes, the manufactured home not on land, which we will cover as the very last form we're covering today. So starting with the overall changes in the sale agreement, a refresh of the sale agreement focused on the following areas. So we addressed formatting. The form is more visually appealing by adding indents, aligning the fillable fields, removing confusing formatting, and standardizing capitalization throughout. For readability, we've changed Latin words to English. We've reduced the legalese and adhered more closely to grammar rules. Organization, we've moved similar topics so that they're grouped together for a more logical flow. You'll see that we've added a section called taxes, and we had taxes covered in several different sections of the sale agreement. They're all now grouped together in one location. Length, we've eliminated unnecessary words and phrases. Usability, we've incorporated improvements suggested by subscribers, lenders, and other real estate professionals. And accuracy, we've updated references to other publications, and I believe there was a correction of statute in one section as well. So at the top of the page, we have the final agency acknowledgement that's built into the residential sale agreement. The fillable sections of final agency acknowledgement have been realigned for ease of use. If you recall, there were broken lines throughout different aspects. It became a little challenging to make sure that you were filling out the correct fields in this section. So those have been realigned. Nothing else has changed in the final agency section. There was a statement on the very last page of the sale agreement, after all of the signatures floating at the bottom of the page by itself, regarding no changes or alterations. We've moved that statement up to the opening paragraph of the contract between buyer and seller. So the statement says, no changes or alterations are permitted to any portion of the pre-printed format or text of this form. Any such proposed changes or alterations should be made on a separate document. So we shouldn't be lining out, crossing out, scribbling. If you are the listing broker seller reviewing an offer, your changes to the offer should be on a counter offer. So rather than having that at the end, after everybody's already gone through and marked up the offer, we've moved it to the beginning. Section 1, the title to this section was changed. It used to be price and property description, but it started by identifying who the parties were. So we simply added the word parties to the title of this section. It is now parties, price, property description. No other changes. Section 5.3, the title to this section was changed from buyer representations regarding financing to buyer's obligations regarding financing. And previously, items 1 and 2 were two separate items talking about the same topic. We actually combined those two to avoid redundant language. So the language now states, and is highlighted in yellow on your screen, not later than a default of 3 business days following the effective date, buyer will submit to the lender who provided the pre-approval letter a completed loan application for purchase of the property. A completed loan application will include the following information: buyer's name, buyer's income, buyer's social security numbers, the property address, an estimated value of the property, and the loan amount sought. So that is the only change to section 5.3. We'll jump into section 10. This is our inspection contingency. The title to this section used to say inspections, health hazard conditions, or something along those lines. So we've abbreviated it just to property inspections. This is where we're creating that inspection contingency should the buyer choose to have one. The opening statement of this section was restructured to open with the topic of professional inspections, followed by the statements regarding environmental issues. The information is all still present just as it was in last year's sale agreement. We just reordered the information in that first paragraph. The reference to OAR, now known as OR content, has been deleted. And a statement was added to clarify that section 10 has no impact on the terms of the private well and the septic on-site sewage addendum if they are attached. So those have their own totally separate independent contingencies. If you define in section 10 a particular inspection contingency for the buyer, just know that Section 10 does not impact private well or septic on-site sewage. Your timeframes for negotiation and potential unconditional disapproval are totally separate. Now, we've added a couple of clarifying options regarding the waiver of inspections, depending on the buyer's intent. So we were hearing feedback from subscribers that buyers were waiving the inspection contingency, but still wanted to have inspections for their own information. The previous inspection contingency had them waiving everything. So we've now created two options. The first option, buyer's waiver of inspection contingency. Buyers satisfied with the condition, they're electing not to have an inspection contingency that would allow them to terminate, but they're reserving the right to conduct inspections for informational purposes only. So if the buyer has those inspections and they end up terminating the transaction, they don't have a contingency that would have protected their earnest money. The second option now for waiver is the buyer's waiver of inspections and an inspection contingency. In this case, the buyer's not going to have any inspections, nor are they going to have an inspection contingency, which would grant them the right to unconditionally disapprove and terminate the transaction. Are there any questions so far on the sale agreement?
Yes, we did receive one from Joe. Why is there no time frame for the informational inspection when the inspection contingency is waived?
I think that is an excellent suggestion to make to the OREF Forms Committee. I think we had in yesterday's class that question, and whether or not there were any invasive inspections might be good additions to that option. So please send that request into customer service at OREF online so that we can get that added to the Forms Committee's meeting agendas in the future.
For the first option, where do you note the length of the inspection? Would you put it in the initial inspection period above?
So this section at the beginning of section 10 clearly states only select one option. So if you are selecting the buyer's waiver of inspection contingency, but they still want to have inspections, my recommendation would be to use additional provisions. If you want to limit the amount of time or limit the scope of the inspections, use your additional provisions section of the sale agreement.
Another question came in. So if they check the first box, the buyer can still back out during the inspection period and get their earnest money back?
If we're talking about the first option for the waiver, no. The first option in section 10 is your normal inspection contingency. Buyer has a default of 10 business days to perform any inspections, negotiate repairs, or unconditionally disapprove by 5 p.m. on the last day of the inspection contingency. That's option 1 in section 10. The option you see on your screen, the first option here, does not grant the buyer a right to terminate the transaction. It only allows the buyer to perform inspections for informational purposes, but the buyer is waiving their right to have a contingency that would allow them to terminate and recoup their earnest money.
We have another question from Kelly. What if the buyer waives contingency other than items of safety or items over a certain dollar amount?
Again, additional provisions is where you're going to want to get into those details. Every buyer is going to have different wants and needs in what they want to incorporate into their inspection contingency. I would recommend using your additional provisions or an attached addendum if you need to elaborate on what the buyer's intent is regarding section 10.
Another question came in. If the buyer waives the property inspection, does that also waive the well and septic inspections?
No, based on that new statement that was added, the selection above does not apply to septic, on-site sewage, or private well if attached. So those are not in section 10. They are their own sections independent of this contingency and are not impacted if the buyer chooses one of these two options.
And just to confirm, there is still an additional provision area of the sale agreement. Is that correct?
Absolutely, yes. With the line to allow you to incorporate an additional addendum if you run out of space.
Thank you.
Thank you. All right, section 12 changes. Now this is your lead-based paint section of the sale agreement. It was brought to the attention of the Forms Committee last year that the language in section 12 did not mirror the language on our OREF 021 lead-based paint disclosure addendum. So we revisited both forms to determine where the discrepancy in the language was and what the actual federal law required. With that, we've deleted the language in the sale agreement that states that the buyer can only cancel the sale agreement if an inspector has identified lead-based paint or hazards. The law does not require that the buyer have an inspector identify those things in order for them to have the right to terminate the transaction. So the language on the lead-based paint disclosure addendum was the correct and accurate language to the law, and we've changed section 12 to mirror that. So once the lead-based paint disclosure addendum is delivered by the seller to the buyer then has their 10 calendar day time period to have a risk assessment done, potentially terminate the transaction, or waive their right to have that risk assessment done. Any questions on that one?
Not on that section, no.
Okay. So the seller representations header, the big bold header that breaks up the sections, was changed to conditions and components of the property, which you'll see right here, conditions and components of the property. And then section 14 is the seller representation section that we mentioned on the buyer and seller counteroffers. So in section 14, the only change that you'll see is the options for the water and waste system have been separated to one per line for ease of identification. So they used to run as one paragraph and you had to hunt for the text for the one that you needed to select here. They're now listed for ease of use. And just to clarify, one of the questions that was asked earlier regarding the representations and the seller property disclosure statement, you'll see right there that this section opens with the statement, subject to any written disclosures made by the seller as a part of this transaction. So seller property disclosure statement, a seller counteroffer to correct any inaccurate information in the seller representations, an addendum provided by the seller to correct those representations. All of that will supersede what is in the buyer's offer to purchase. No other changes occurred in section 14. Section 15 is the as-is provision. This was simply numbered from section 16. There were no other changes. Section 16, approved uses section, was relocated from section 34, and the section was updated to reflect changes in the applicable statute. Section 17, the definition of planned community was moved from section 32, which was our definition section. We moved it to section 17 because this is the only place planned community is addressed. We also added a definition of townhome for buyers and sellers' clarity, and more precise language was added regarding the inclusion of Form 024 Homeowners Association Townhome Planned Community Addendum. So now in the buyer's offer, if the buyer marks yes or unknown, the language now says, buyer has attached 024 Homeowners Association Townhome Planned Community Addendum to this agreement. Onus is on the buyer to get that addendum incorporated into the contract. So previously it just said that the form would be attached. We've added that clarifying language that the buyer should be attaching it with their offer. Section 26, yes.
Question just
Yes.
came in. Is a planned community any neighborhood with a CCNR?
So planned community means a residential subdivision, not a condominium or timeshare, in which owners are collectively responsible for part of the subdivision. That would be the definition of planned community.
Thank you.
You're welcome. Section 26, this is the utility section. It was relocated from section 33, no other changes. Section 28.1 is earnest money deposit instructions to escrow. This was renumbered from 27.1, no other changes. Section 28, earnest money refund to buyer, was renumbered from 27.2. And we've removed the previous item 1, which referenced what happened to the earnest money if the seller rejected an offer. Because our sale agreement now specifies that earnest money is not deposited into escrow until the offer has been mutually accepted, there wouldn't be an occasion where escrow is holding that earnest money when an offer is rejected by a seller. So we've removed that language since it's unnecessary. Section 28.3, earnest money payment to seller, was renumbered from 27.3. These are all renumbering changes. So closing was renumbered to 29.1. The closing disclosure renumbered to 29.2. Just know there were no other changes other than those general form changes we covered in the beginning. No substance changes to these sections. Same thing with section 29.3, which is notice regarding title insurance costs. Deed was renumbered from section 30. Possession was renumbered for, oh, I got a little typo there. Look at that, 2 section 30s reference there. Section 31, possession, was renumbered. And so section 31.1 is now addressing possession. We've restructured this section to avoid confusion regarding possession when a tenant is occupying the property. So the next section now starts with a clarifying question. Is one or more tenants currently in possession of the property? Yes or no? We need to know that information before we proceed, because we need to identify who has possession and can deliver it to the buyer. If the seller has possession, we can skip to the if no section down below and just address how possession will be delivered to the buyer. But if there's a tenant in the property, we have to identify, is the seller going to remove the tenant prior to closing, or is the buyer accepting the tenant and becoming the new landlord? So the question first clarifies, is there a tenant in the property? If yes, we select one of the 2 options. The first option, seller will remove all tenants prior to closing, pay any legally required tenant relocation costs, and deliver possession to buyer by 5 p.m. on the date of closing. That's if the buyer is intending to have the tenant vacated before they even take ownership of the property. If the buyer is willing to become the new landlord, you would select the second option. The buyer will accept all tenants at closing, and unless provided otherwise in this agreement, all rents will be prorated as of the close date, and all deposits held on behalf of the tenant by seller will be transferred to buyer through escrow. So nothing has changed in that paragraph. It's the first option where the seller is removing the tenant. We've clarified that if the seller is responsible, then the seller will remove the tenant and deliver possession to the buyer by 5 p.m. on the close date. If there is not a tenant in the property at the time the offer was written, we skip straight down to the if no section. Possession of the property will be delivered by seller to buyer, and we select one of the 3 options, the same 3 options that we've had in this section. Now we've included that statement, seller will remove all of seller's personal property, including trash, prior to closing. Are there any questions on this section?
Oh, we definitely have a few.
I thought so.
The first one's from Maddie. What about a rent back when the property is tenant occupied?
So if a property is tenant occupied, we're not talking about a rent back. The buyer is becoming the landlord. Once a transaction closes, the seller has absolutely no legal rights regarding the tenant or the property. So we're not talking a rent back in that case. That is the buyer becoming the new landlord and accepting responsibility for the removal of the tenant at a later date. Rent back or our agreement to occupy is specifically addressing if a seller is going to remain in possession of the property after the close date. And that section hasn't changed. We'll go to that one on the next screen, but we still have agreements to occupy being incorporated into the contract if the seller is going to remain in possession beyond closing or the buyer is moving in before closing. But when a tenant is in the property, there really are only two options. The seller's removing the tenant prior to closing, or the buyer's accepting the tenant and becoming the new landlord. Now, the seller may deliver notice to vacate to the tenant during the course of the transaction, but if the tenant is still going to be in the property at closing, the buyer becomes the landlord. The seller cannot finish the process of removing that tenant since they have no further legal rights to the property.
Another question is, what if it's unknown whether the occupant is a tenant or not?
That's a great question, and that's definitely a clarifying statement question you will want to ask the listing broker. If you don't have that information at the time of drafting the offer, my recommendation is to use your additional provision section to spell that out. I think we had yesterday that question came up also in terms of a roommate. And if there is a roommate, the seller may be in possession of part of the property, but the roommate also has some tenant rights to the property. So with each transaction, you may have some nuances based on who's occupying what part of the property. Your additional provision section is your friend there. I would definitely incorporate in some language that addresses the seller clarifying whether or not there's any tenants in the property within a certain number of days after the offer is signed and accepted, or include something in there that the seller is responsible for ensuring that the property is fully vacated by any guests or tenants prior to closing.
Another question came in from Kimberly. Shouldn't the seller will remove tenants always be checked in case the seller has a tenant move in during escrow?
Well, it depends on the intent of the party. So if the buyer is purchasing the property as an investment property, they may want a long-term tenant to stay and continue paying rent. It's hard to say that there's a standard you should always mark. I think every buyer is going to have a different intended use of the property.
We also have another question from Maddie. What about the case of a multifamily property where the buyer is accepting tenants in one or more units and is also moving in themselves?
Again, additional provisions is the place to clarify that. So which unit is the buyer asking the seller to remove the tenant versus which one the tenant would remain. So if we're talking 1 to 4 units, you would be using a residential sale agreement for that. You'd want to make sure you're specifying in additional provisions what happens with each of those units.
Another question came in asking if why the unknown option is not part of this section.
This has to be clearly defined for escrow and for the parties. I don't know. Do you mean unknown in terms of whether or not there's a tenant in the property? If we have an unknown, we won't be able to define the possession section. The buyer needs to clearly express with their offer to the seller what the intent is. So if the buyer plans to move in, let's say it's a single family residential home and it's tenant occupied, the buyer needs to put the seller on notice. Under these terms, and my offer includes seller, that you need to remove that tenant prior to closing.
Thank you.
You're welcome. All right, section 31.2. This is a renumbering of the possession before or after closing. So no changes to that section at all. It still says that if the seller is going to remain in possession beyond the close date, or the buyer is going to occupy before the close date, the buyer is going to attach the agreement to occupy to the offer. A new header was created titled Taxes, which I mentioned earlier, and we moved all topics relating to tax implications into one area of the sale agreement. So this starts with 32.1, which is the Oregon State Tax Withholding Obligations. This was relocated from section 15.1, and this section started with the language seller advisory. We removed the seller advisory, left the section to seller state tax withholding obligation. Section 32.2 changes to the FERPTA tax withholding obligations. This was relocated from section 15.2, and we did have some general language changes. All of the terms regarding the FERPTA section remain unchanged. It's simply the language that we use to explain it has been modified to more understandable terms for buyers and sellers. So if a seller is a foreign investor, the buyer is responsible for withholding a portion of the seller's proceeds to satisfy the FERPTA requirement. If the seller is representing that they are not a foreign person, they agree to complete the certification form and deliver it to escrow. The parties are advised that escrow may or may not agree to act as a qualified substitute. The parties should verify. If escrow is not willing to act as a qualified substitute, either party can move the escrow to another company who will handle that, and both parties will share in the cost of that change of escrow. So all of those elements are still very much intact in the FERPTA section. We've just rephrased how we're expressing that to the client in more clear, understandable language. Section 33, this is 1031 exchange, renumbered from section 35. Section 34 changes. Levy of additional property taxes was renumbered from section 36.1. And in this section previously, it stated that the buyer had the right to terminate the transaction if the property was disqualified from special use assessments or lost its tax deferral status. Just as a blanket statement, the buyer had the right to terminate. We've added the clarifying statement that this only applies if the seller failed to disclose that upcoming disqualification or loss of status to the buyer in writing prior to closing. So as long as it was disclosed to the buyer, they don't have that opportunity to terminate the transaction. So you'll see that highlighted statement was added. And if seller did not disclose the upcoming disqualification or loss of status to the buyer in writing prior to closing. Section 35, historic property designation, was renumbered from section 36.2. The header for definitions and instructions has been renamed definitions and miscellaneous. Section 36, this is now the definition section, and it's an independent section with terms relocated from section 32. We'll take a look at what that section looks like in just a moment, but a couple things to note. All the defined terms have been alphabetized. The term effective date was created to replace the previous language, which was the date when this offer is signed and delivered. Deposits is now a defined term, and the definition of smart home features was relocated from section 20 because the term smart home features is actually used in a couple of different places in the sale agreement. So we wanted to make that an all-inclusive defined term in the definition section. So you'll see the definition section here on your screen. We've also added that definition for deposits, means the deposit of any additional means the deposit and any additional deposit described in section 1 of this agreement. Effective date means the date when the sale agreement has been signed and delivered. And then the definition of smart home features is exactly the same as it was. We have simply relocated it to the definition section. Section 37, miscellaneous, is a new section with terms relocated from the previous definition section that didn't fall under the category of a definition. We also elaborated a bit on the term days, and I'll explain that in just a moment. So here's your miscellaneous section. Time is of the essence. Agents and their firms are not parties to the contract unless specifically identified in the contract. And when we get to the part regarding days, we wanted to clarify the calculation of days in the sale agreement when it is defined as the date the buyer is entitled to possession. Now, the best example I can think of is the proration section, where we're instructing escrow how to handle prorations. If you were to mark the box that they're calculated based on the date the buyer is entitled to possession, but there's a tenant in the property and the tenant is staying and the buyer is not getting possession, then we added the clarifying language that for that purpose only, it will be deemed the date of closing. So escrow will calculate the number of days for prorations based on the close date if there's a tenant in the property, and we marked that the buyer is the date the buyer is entitled to possession. Section 38, the filing of claims, renumbered from section 37. So this is our dispute resolution process. Other than changing of sections, there were no changes in the dispute resolution process. Section 41, the offer to purchase, was renumbered from section 40. This is the point where the buyer is actually signing their offer. And then section 42, agreement to sell acknowledged, was renumbered from section 41. And there was a statement added as a reminder to the seller to review the seller representations and correct any inaccurate representations in writing. So before the seller accepts an offer, the seller is reminded to go revisit section 14 and make sure that information is correct. That's the last change to the residential sale agreement. Are there any additional questions on that one before we move on to the next form?
We have a few.
Okay.
Okay. Do you need to explain when delivery happens under the effective date? Or
go ahead.
And then it ties into another question that we got, is effective date the date it's signed by both parties, i.e. mutual agreement? Seems like they may need to clarify, since it sounds like the date or the offer was submitted by the buyer's agent.
Yeah, so let's go back to effective date, the definition section here. So effective date means the date when this agreement has been signed and delivered. Signed and delivered is still a defined term. I believe it appears somewhere in the sale agreement still, but signed and delivered means the date and time the seller and buyer have signed the agreement, transmitted it to the other party, either by manual delivery or by fax or electronic transmission. So both has to occur. In order for the effective date to start triggering all of your timelines in the contract, it needs to have been signed and delivered back to the offering party. So if it was an offer to purchase, the seller signs it and the listing agent delivers it back to the buyer or buyer's agent. That is the effective date when both events have occurred. It's been signed and delivered.
We have another question from section 14 of the sale agreement. Does the buyer fill that out, or does the seller fill it in when they sign the sales agreement?
The buyer fills out section 14 based on representations made by the seller in the marketing of the property. So I believe the fields regarding water source and waste system are identified in most MLS systems, to my knowledge. If the property is not listed, a buyer's agent may want to ask the listing broker for that information or write into additional provisions that the seller will identify upon acceptance of the offer.
We had another question come in and ask about, have they increased the additional provisions section? There is not nearly enough room for these statements, which means the additional sale agreement addendum should be included with the sale agreement and noted in the additional provisions section.
So the additional provision section is the same size as it has been. However, we have and as always, it has a line for you to incorporate in an additional addendum. So if you do not have enough space in additional provisions to cover the intent of your buyer, you have the option to attach addendum A and continue on with what you needed to add in additional provisions.
We did get another question regarding holidays. Where should someone go to actually determine the legal holidays?
Okay, so business days means Monday through Friday, except days that are recognized by Oregon or the United States as official holidays. Official holidays are defined by statute. So I do believe OREF may have put out an annual holiday schedule, but if not, Christina, we might want to look at doing that. What I usually do when the question comes up, is something a holiday, is I Google Oregon legal holidays and I pull up the actual statute. What I have learned is that going to different government websites to try to find out what they deem as holidays is deceptive, because they may be observing a day as a day off for that particular government agency's employees, but that doesn't necessarily mean it is a legal holiday. So if you look at Oregon statute, you'll notice that the day after Thanksgiving is not under statute a legal holiday. It is observed in some cases, depending on the different government agencies who may be open or closed and conducting business that day, but under statute is what we're looking for in terms of legal holidays.
Thank you.
Anything else?
I'm just scrolling down the list here. So if the sale agreement is mailed, you must send certified mail to verify receipt of accepted agreement to start your timeline.
No, I don't believe I recall seeing that language anywhere. Is that in this section here?
I am not sure. Is there something that talks about it being mailed instead of electronically?
So there was previously, yes. So it's in electronic transmission, I believe is where.
Right there on the screen.
Yeah. So such as regular mail, certified mail, overnight, they should specify an additional provision. So yeah, that language hasn't changed. That's been in the sale agreement, that the sale agreement is assuming the parties are going to use electronic transmission. If a buyer or seller intends to use snail mail through the course of the transaction, they need to identify in section 23 that that's how they plan to communicate documents back and forth through the transaction, which means everybody may need to adjust their timelines, because a negotiation period is going to need to be expanded to allow for that mail system.
Thank you.
You're welcome. All right, so the last form that we have changes on is the manufactured home sale agreement without land. This is form 012. So on this form previously, it started with a final agency acknowledgement section that mirrored all of the rest of the OREF sale agreements. The challenge is that a manufactured home without land is not real property, and it is not governed by the real estate agency. DCBS is actually who is governing the sale of a manufactured home on leased land. For that reason, We've restructured final agency just to make it an acknowledgement of agency relationships in the transaction, but it does not need to meet the statutory definition of the true final agency acknowledgement. We also added a statement that informs the parties of the license status of the agents involved and their firms. So in order to sell a manufactured home without land, the firm needs to have a license with the DCBS. And so we have replaced real estate license numbers with that DCBS license number on the acknowledgement of agency relationships. So we're identifying still who's representing the buyer and who's representing the seller, but we don't have the same fiduciary duties as outlined in your final agency acknowledgement when we're dealing with a manufactured home without land. And so we've removed the real estate license for the buyer's agent and the real estate license for the firm, and that's been replaced with the DCBS license number. And that is the last change that we have. So I am glad to stay on and field any additional questions. If you got all of your questions answered, you are welcome to hop off. We will be issuing CE certificates as quickly as we can. Just keep in mind, we had about 540 people on the call today. So quite a few certificates to generate. Give us a couple of days to get those done and emailed to you. But I am glad to hang out for the additional 20 minutes and answer any questions that you have regarding the form revisions that we've gone over today.
There are a few that are in the system, and let me see if I can find them. Everybody's typing away at the moment.
I see that number climbing.
I know it does. Let's see. So I know that there was some questions online about the offer summary and the population of that form, that we requested the platform providers to take it from the sale agreement and push it into the offer summary form. So we're working with them to make sure that that's the flow that's happening on that document. The question came in, is the advisory form required? And I know that there's many advisory forms.
There are lots of advisory forms. There is nothing in the OREF library that OREF deems required. The requirement of documents is a specific question to ask your firm's managing principal broker. What are the standards of risk reduction that they want to see in your brokerage? So OREF cannot answer that question for you, whether or not something is required, with the exception of Form 42, because statute says it's required. We as licensees are required to deliver that initial agency pamphlet to any prospective client at first substantial contact.
We have a question from early on in our presentation. I think at the time stamp that I'm seeing, it was probably document 010. And the question was, so this came about due to a legal case or dispute. Can you reference the legal case? I'm not sure if there was a change to the document 010.
So 010 is the final agency acknowledgement addendum. Here, and all we did was made sure that, one, it was in compliance with statute, and we made it universal to our addendum library by incorporating buyer, seller, and property address at the top of the form. I'm not aware of any dispute that this was related to.
Thank you. The new construction sale agreement, does it have similar changes that you referenced for the residential sale agreement?
Yes, so all of the sale agreements in your OREF library will see the same changes you saw on the residential sale agreement when applicable.
Thank you. Regarding the inspection contingency waiving, is there a private well addendum the buyer can back out based on the well addendum, even if they've waived the inspection in section 10?
Correct, and that's why we added that clarifying statement in section 10 that waiving the inspection contingency in section 10 has no impact on the well addendum or the on-site sewage system addendum. Those are independent contingencies. They are not tied together at all. Waiving one has no impact on the other.
Circling back to the change of the library from the 2021 version to the 2022, is there a grace period to use the 2021 version forms before being required to use the 2022 version?
Absolutely, yeah, I covered that earlier. There are no statutory changes to the sale agreement. So if you receive an offer on one of your listings and it's on a 2021 sale agreement, there were no legislative changes, no law changes that would impact buyer or seller. If the parties agree and they proceed with that contract, totally fine. Ideally, we want to transition as quickly as possible to the new version of the forms, but I think we all have to have a little grace that change. It takes all of us a little bit of time to adapt to change. And so there is a possibility that we'll have some overlap right now between the 21 and 22 forms.
Thank you. Going back to the manufactured home not on land sale agreement, can you clarify the license number change?
Yes. So let me get to that slide. Oops. Well, now I exited all the way out. Let's try this. Go backwards. No. All right. So the license change on the manufactured home, it doesn't require a real estate license to sell a manufactured home on leased land. If a manufactured home is on its own land, it becomes real property. But if it's on leased land, it's considered personal property, not real property. Therefore, our real estate licenses have no bearing on that transaction. It is the DCBS license that is what directs who can or cannot broker the sale of a manufactured home. So that is why on the sale agreement, specifically for manufactured homes without land, we're asking for the DCBS license number, not the real estate license number.
Thank you. We also had another question about manufactured properties. What about manufactured homes that are on land but not detitled?
So if they're on land, my understanding is that it is real property. It becomes real property. I can't speak to the detitling. I am not a manufactured home specialist at all. I would recommend you start with your managing principal broker or possibly legal counsel to get clarification on that.
Thank you. Going back to some lead-based paint discussions. If the buyer does not explicitly waive the right to test for lead-based paint, does that mean they don't need to do any actual testing or inspections of paint in order to terminate the sale agreement?
That is correct. That is what the federal law says. That is what our lead-based paint disclosure addendum has said. And it is now what the sale agreement says so that we are consistent with the law.
We've got a question again about lead-based paint. I'm just reading these, sorry if there are repeats. If the buyer does not explicitly waive the right to test for lead-based paint, they don't need to do any actual testing of paint in order to terminate the sale. I think that's the same answer there. What happened buyer waived inspection, but the lender found out something not past the inspection?
Lender conditions are not related to the inspection contingency. Lender conditions fall under your financing contingency. So the lender discovering a condition issue with the property is going to fall under your failure of the financing section 5.3.
Thank you. I'm just scrolling through to see if there's another question here. Is it all right to add an agent license number to the agent line for manufactured without land? So I guess they're asking if they can put both of their license numbers in there.
So a real estate license is not needed to sell a manufactured home without land. So there's no need to write it in. The only thing that matters is that DCBS license. I guess there's no harm if you want to write it in after your name, but it should not be written in replace of the DCBS license number.
Thank you. Let's see if we can see any more questions coming in from anybody. I think we've answered quite a number of questions, and the staff will be following back up with the Q&A and the chat to see if there's additional questions that we need to respond to that we haven't gotten to today. But I'm just going to take another glance through here real quick. Section 14, what about radon?
In section 14, to my knowledge, there's the only question in section 14 that would apply is hazardous substances. Section 14 is the seller representation. So if the seller has knowledge of high radon levels, that would definitely fall under the seller property disclosure statement. But if seller property disclosure doesn't apply, then the seller representation should probably be corrected to address a known carcinogen.
Okay. We got a question from Mindy about CCNRs. So what about CCNRs, but no HOA fees are being collected anymore? I've gotten requests from listing agents asking me not to include it because the HOA is effectively defunct.
So I'm a big fan of your buyer submits whatever offer the buyer wants to submit, regardless of how the listing agent instructs you to submit an offer. So if the buyer wants to request those documents, they certainly have the right to. It's then the seller's opportunity to counter and clarify that there is no active HOA and that the only documents that would apply would be the CCNRs that are recorded against the deed.
Thank you. We've got a question about condo sale agreement on page 11, lines 203, 231, which is not currently on our screen, is requesting the same information as the planned community and townhome addendum. Do they both need to be provided in an offer?
No, they do not. So to your point, the condo sale agreement has that entire contingency built into it already. So it would be a repeat of the same information if you attached the townhouse plan community addendum. So townhouse plan community addendum is not intended to be, sorry, homeowners association townhome plan community addendum is not intended to be used with a condo sale agreement.
Thank you. And then somebody needed to clarify on this manufactured home sale agreement what DCBS stood for.
DCBS is the Department of Consumer and Business Services.
Wonderful. And then I think our last question of the day is, they notice at the bottom of the sale agreement that the wording has changed where the licensee of the document space is left. Is the licensee name inserted in that space? And I think they're talking about the footer.
Yes.
And they would be correct that their name gets inserted into the footer to show that they have licensed the use of the OREF library.
Correct.
All right. I think we've got it.
All right. Thank you all for joining us. Have an excellent Tuesday, and please make sure that you are sending in your suggestions and feedback to customer service at orefonline.com. We look forward to serving you again in 2022.
Thank you, everybody.